Hello there guys, Tyranzel here, and good news to all of my artist friends out there. The US Supreme Court declines to hear dispute over copyrights for AI-generated material. So basically, if your piece of work is generated by an artificial intelligence, then you can't copyright it. And that's good news to all of my artist friends, because we're all sick and tired of this. March the 2nd. On Reuters, the US Supreme Court declined on Monday to take up issue of whether art generated by artificial intelligence... yeah, not too happy with calling that art. It's not art, guys. Reuters. Stop calling it art, it's slop. Generated by artificial intelligence can be copyrighted under US law, turning away a case involving a computer scientist from Missouri who was denied a copyright for a piece of visual slop made by his artificial stupid system. Okay, he's a computer scientist, he's not an artist. The plaintiff, Stephen Thaler, had appealed to justices after lower courts upheld a US Copyright Office decision that the AI-crafted visual nonsense at issue in the case was ineligible for copyright protection because it did not have a human creator. So that's right, folks. If you don't have a human who make that, piece of work, then it's not art, because of that, you cannot copyright it, right? You need a human to make art. You need a human to copyright it. Thaler, of St. Charles, Missouri, applied for federal copyright registration in 2018, blah blah blah, recent AI, we don't care, that's what his company is. The Copyright Office rejected his application in 2022, finding that creative works must have human authors to be eligible to receive copyright. That's good news. US President Donald Trump's administration had urged the Supreme Court not to hear Thaler's appeal. Well, that's interesting. I was not expecting the Trump administration to do that, but, well, I guess good on them. Copyright Office has separately rejected bids by artists for copyrights on images generated by our AI super... No. Bids by artists, AI system... No. Guys, if it's not made by an artist, if it's made by an AI, then, you're not an art. They're not artists, they're AI prompters. Stop calling them artists. Those artists, in very big quotes, were entitled to argue they were still entitled to copyright because blah blah blah, the AI assistants. No. Federal judge upheld the office decision in 2023, writing that human authorship is the bedrock requirement of copyright. So, that's right, guys. That's right. So, Supreme Court basically says that in order for your work to qualify for copyright, it must be made by a human. So, and then the rest is just stuff about previous cases. So, don't really need to read the rest. But yeah, what do you think, guys? Is that good news? I think that's good news. So hopefully, I will alleviate a lot of people's concern about AI ever being used for copyrights, because you can't. And so, yeah. And if you like this video, please do share and subscribe. And thank you for watching. Goodbye, guys. Take care.